You want to wait for Nasli? Okay. Good morning, everyone. We are here on the Town of Pembroke Park Special Magistrate Code Enforcement hearing. Before we begin, I will be reading an opening statement as to how these proceedings will be governed, so I thank you for your indulgence. Ladies and gentlemen, thank you for being here today, and welcome. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the special master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These hearings are conducted by a special master, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My name is Andre McKinney. My responsibility is to act much like a judge in a court, and that is to hear cases presented by code enforcement officers and to hear contradictory arguments presented by alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party called him or her first to testify, and to rebut evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for a correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have authority to assess and order the payment of civil penalties, to issue orders having the force of law to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find there is substantial, competent evidence that the named violator was responsible for that violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of hearing, not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of a special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation charged, you will be assessed an administrative fee of $100. The town representative will present their case first, and the alleged violator will present their case after. I will consider all evidence and render a decision after all arguments are heard. All those who intend on testifying in today's hearing, can you please raise your right hand? If you're going to be speaking on a case, raise your right. Does anyone in the audience speak Spanish? Can translate that if she's going to testify, she has to raise her right hand to be sworn?
We'll swear her in when she comes up.
Oh, okay. Okay, you can. We'll swear her in when she comes up for her case. Okay, everyone else, if you could please raise your right hand. Do you swear and affirm that the testimony you will provide in today's proceedings will be the truth and nothing but the truth? Yes. Okay, thank you. Officer Ramirez, whenever you're ready, we can.
Roll call. Chief Code Compliance Officer Joseline Ramirez present.
Assistant Town Attorney Brian Sherman.
Special Magistrate Andre McKinney present.
Code Officer Gene Gusson, present.
Nasli Cardona, Code Clerk, present.
And then we have the adoption of minutes for August 21, 2024 and September 18, 2024.
Any additions or modifications, or are we moving as presented?
As presented.
Well, I have one addition and modification. Case 7 point, on 7
Well,
point.
I'm sorry. We're still on the minutes, right?
Yes.
Oh, I'm sorry. I thought we were on the agenda.
We're getting there.
Okay, adoption of the minutes, so adopted as moved.
Okay. And now the deferrals, additions, and modifications to the agenda. We have case 5272, removed from the agenda, property owner approved for amnesty. And then I'll pass it on to Attorney Sherman.
7.4 on your agenda, case 9024. We're going to continue that to your next available hearing, whether it be December or February. One of the witnesses, Mr. Pizzillo, is unavailable due to an emergency in the family. I spoke with the attorney of record on the case, Mr. Pizzi. That's why he's not here today. And we're going to renotice the hearing for that purpose at a later date. There was a companion case that's not on the agenda for signs with the same respondent, with Mr. Pizzi as well. And that case is complied and it's not on the agenda.
And for the record, is it case number 9026 or 9024?
2-6.
Okay, okay, perfect.
2-6.
Okay, the modifications as noted, unless there are any objection, are so moved. We've sworn in the witnesses. We can call the first case. I don't know if we have any attorneys signed up.
Are there any attorney present? No? Okay. We'll proceed in the order of the agenda, the sign-in sheet.
Nasli, is this mine? Oh, okay, thank you.
First case is on section 7.8 on the agenda, case 9628. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 9628. Property owner JAHOOR LLC, site address 2111 John P. Lyons Lane, Pembroke Park, Florida. A notice of violation was sent by regular mail, May 9, 2024. Certified mail on September 6, 2024, posted to the property and town hall, October 4, 2024. The violations are for item number 1, operating without a business tax receipt. Item number 2, installation of tent canopy without a permit. Item number 3, installation of aluminum sign without a permit. As of September 5th, 2024, all of these items were non-compliant. However, the property owner did mention that the canopy has been removed, and he did apply for BTR, so he's working on inspections, and he's also working on getting a permit for the sign. And so my recommendation is to give 60 days, if not a per diem of $250 and a $100 admin fee.
Is there anyone here on case number 9628? Property address, come on up. Oh, no, at the lectern, yes.
And if you can press the button on the mic, so it's green, turns on green?
Yeah.
Okay.
Okay, and so you'll speak in the microphone. If you could please state your name for the record and who you are in relation to the subject property.
Steve Sukhdev, and the manager of the business.
Okay. So the town has presented the case. Looks like there's some violations that are existing by the testimony. The canopy is said to have been removed.
Yes.
And the BTR application is submitted, but that hasn't been issued. The town is offering 60 days to come into compliance or face a $250 a day fine for each day you're not in compliance.
Okay. Yes.
Okay, so you're in agreement with?
Yes.
Okay. Unless there's anything else by either side, I'll give oral pronouncement.
Okay.
Okay. I don't have anything else.
Would you like to say anything?
No.
Okay. You do have the opportunity to say whatever you want.
Right.
And you understand what we just said?
Yes.
Okay.
Because I think I was here on Friday and they said that the permits are being in review, so it should be coming through anytime soon.
Okay, very good. Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the town's position. The respondent is ordered to come into compliance within 60 days or face a daily per diem fine of $250 each day that the property is not in compliance. The respondent is also assessed $100 administrative cost for today's hearing.
Understood.
Okay? Good luck to you.
Thank you.
You're welcome. Thank you. We can call the next case.
Next case on section 10.1 in the agenda. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 6131. Property owner Ana Julia Labrada Batista. Site address 3140 West Hollandale Beach Boulevard, Lot 813, Pembroke Park, Florida. A notice of hearing to abate fine was requested by the property owner on October 1st, 2024. It was posted to the property and town hall October 4, 2024. It is the town's motion to abate the fine of $26,450, reduce it by 90%. That total is $2,792. That includes all administrative costs.
Officer Ramirez, that's coming from $26,450?
Mm-hmm.
Okay,
Including the administrative costs.
okay. And that represents a 90% reduction?
Yes.
Is there anyone here on case number 6131? Property address located at 3120 West Hollandale Beach Boulevard, Lot 813?
Sure.
Oh, okay. Ana Labreda? Okay.
Yeah, if you
Yes,
could.
please. Okay. Can you state your name for the record?
My name is Randall Perez.
And Mr. Perez, thank you for serving as an interpreter for Miss Anna. If you could just raise your right hand once again. Do you swear and affirm that your translation from English to Spanish and Spanish to English will be the truth and nothing but the truth? Okay. And so I'm going to
We have to
swear her in, let her know. Does she swear and affirm that the testimony, raise her, yes, thank you. Does she swear and affirm that the testimony she will provide will be the truth and nothing but the truth?
Ajá. Yo juro para que voy a decir la verdad.
Okay. Okay. So we're here on the motion to abate. The property's in compliance, so congratulations. The town is offering to abate $26,450 by 90%, which brings it down to $2,792.
Ella dice que ya como la propiedad está de acuerdo con la regla, ellos están bajando la multa de 26,000 a 2,600 por 90%.
A 2,600, sí.
Yeah. She says yeah.
Okay, and then one last thing, can she state on the record who she is in relation to the subject property?
Que diga quién tú eres en relación a la propiedad.
No, yo compré esa propiedad y no sabía que tenía irregularizaciones. Cuando en un tiempo de vivir ahí, me enteré que tenía esa multa y tenía infracciones.
Okay, she says she bought the property and she wasn't aware of those violations that were going on, and she found out shortly after she purchased the property.
Okay, thank you for sharing that, and congratulations, the property is in compliance. So,
If she can just state her name for the record, if
yes,
she can actually.
Sí, Ana Julia Labrada Batista.
Okay.
okay, so unless either side has anything else to add, I'll give oral pronouncement. So again, the town is offering to reduce the fine from $26,450 to $2,792.
1,792 pesos.
Madam Magistrate,
Yes,
Y la pago.
you may want to
It has
ask
to be
the respondent
paid.
the length to pay for. the
I was
city.
gonna do
Thank
that,
you.
yeah.
Actually, what she just asked, how
Yeah.
can she?
Yeah, I can't give a long paragraph because you might not remember it all, so I've learned to chop it up. She has to pay that within 30 days.
Tienes 30 días para pagar.
If she needs more time, now's the time to tell us.
Si necesitas más tiempo, ahora es el tiempo para eso.
Sí, necesito
Necesitas
más tiempo.
She says she does need
Sí.
more time.
Okay. Does the town have an objection to more than 30 days?
No.
Okay. How much time does she need to pay?
Tiempo necesita.
¿Cuánto tiempo dice que necesito?
Te está preguntando
Ah,
cuánto
sí.
tiempo necesita.
No sé, como 3, 4 meses.
She says about 3 or 4 months.
Is there an objection to?
No. We can give her the 120 days.
Yes.
Yeah.
Okay. Okay, 120 days. The town has no objection.
3 meses. Ok.
If it's not paid in 120, it goes back.
Now, this part is extremely important as well as everything else. If she doesn't pay the $27.92 within 120 days, excuse me, the original amount of $26,450 will resume.
Si no paga los $2,700 en los 120 días, se convierte en 26,000 otra vez.
Ok.
Okay?
Okay, great. Unless either side has anything else, I'll go ahead and give oral pronouncement. Based on the test, I don't know if you, does she have anything else?
¿Otra cosa que decir?
No, solo eso.
Okay.
Gracias, muchas gracias.
You're welcome. I understand that part. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for mitigation or abatement. The property is in compliance. The respondent's fine amounts are mitigated from $26,450 to $2,792. That includes the administrative costs. The mitigated amount must be paid within 120 days or the original fine amount will resume. Good luck to you. We'll give you a copy of your order.
Ella solo repitió lo mismo otra vez. Okay?
Ok, gracias.
Thank you. We can call the next case. Oh, okay.
Next case on section 7.7. Chief Co-Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 9443. Property owner 5525 Southwest 41st Street, Pembroke, LLC. Site address 5525 Southwest 41st Street, Pembroke Park, Florida. A notice of violation was sent by regular mail on March 25th, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail September 13, 2024. Posted to the property and town hall October 4, 2024. Violations are for item number 1, operating without a business tax receipt. Item number 2, outstanding certificate of use renewal and fees. Item number 3, installation of a monument sign without a permit. The permit that was initially applied for had expired, so therefore it's considered now work without permit. The property manager did contact us and is working on the 3 items. Therefore, it's my recommendation to give them 60 days to correct everything. If not, a per diem of $250 and $100 admin fee.
Is there anyone here on case number 9443? Oh,
And when your case is called, feel free to come to the podium.
good morning again.
Good morning again.
If you could please state your name for the record and who you are in relation to the subject property.
Yes, my name is Randall Perez, and I'm the current property manager for Leon 41st, which is the property in question.
Okay, so it looks like the violations cited for are still not in compliance. The town is offering 60 days for full compliance or a $250 per day daily fine and $100 administrative cost for today's hearing. What's the position?
Yeah, we accept. I actually spoke to Miss Nasli Cardona yesterday. Corporate had already sent out the documents and the application for everything done, and she stated that they'll get to it by the end of the week.
Okay.
And I was just advised to come and show face and explain the situation regardless.
Oh, okay, great. Well, unless there's anything from either side, I'll go ahead and give oral pronouncement. Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the town's position, the existence of a violation. The respondent is ordered to come into compliance within 60 days or face a daily per diem fine of $250 per day. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you. You get a copy of the order.
Thank you.
Thank you, Mr. Perez. Thank you. We can call the next case when you're ready.
Next case on section 9.1 on the agenda. Chief Co-Compliance Officer Joseline Ramirez for the Town of Pembroke Park. Case 8547, property owner Ventura Unit 120 Inc., site address 5100 Southwest 41st, Pembroke Park, Florida. A notice of hearing to extend time was requested by the contractor on September 19, 2024. It was posted to the property and town hall on October 4, 2024. So it's everything was very close into getting into compliance. I think it may be in compliance as of today, but we want to give the 30 days to ensure everything is all in compliance.
Okay. Is anyone here on case number 8547, 5100 Southwest 41st Street? Come on up. And for the rest of the audience members, when your case is called, the case number and the address, you can go ahead and come up and stand at the lectern. The code enforcement officer will present the case first, and then you'll have an opportunity to respond. Good morning. If you could please state your name for the record and who you are in relation to the subject property.
Yeah, good morning. My name is Albert Montoto.
Okay. Good morning, Mr. Albert. So it looks like, based on the testimony, the violations are shy of being in full compliance. The
Right.
extension that the town is willing to offer is an additional 30 days. What's your position with regards to that?
Okay, we already complied with the all the permits and inspections on the 11th. It may got into the record a little later after that. By the 11th, everything was done. And when I got the permit on the 16th, August 16th, my understanding was that I have 180 days
For the permit?
for the permit.
Okay.
And then soon after that, I find out that it was not. And I had to run and put a lot of pressure into a lot of people, and I got that done.
Okay.
Thank goodness. But it was really tough to get it done.
Okay. So is 30 days going to be enough? I know you meant.
30 days? I mean, yeah.
That would be
Okay. Okay, we'll stay in contact with Officer Ramirez. It looks like you are on top of this, so that's great. Unless anybody either side has anything else, I'll give oral pronouncement. Do you have anything else to add?
No, that should do it.
Okay, perfect.
Thank you.
You're welcome. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is hereby ordered to come into compliance within 30 days. Failure to come into compliance and correct all violations will result in the fines continuing to accrue daily until the property is in compliance. There is $100 administrative cost for today's hearing also assessed. And you'll get a copy of your order. Officer Ramirez, the fine amount on this one was at, let's see, $250? The running fine?
Let me get that for you. Oh, sorry, I closed out. 2547. Yes, 250.
Thank you. Okay, we can call the next case.
Next case on 7.6 on the agenda. Chief Code Compliance Officer JOSELINE Ramirez for the Town of Pembroke Park, case 9195. Property owner MITZA LACROIX, BENSON and Baronvil Marie Augustin. Site address 4800 Southwest 36th Court. A notice of violation was sent by regular mail January 12, 2024. And notice of formal hearing with a copy of the notice of violation was sent by certified mail September 6, 2024. Posted to the property and town hall October 4, 2024. Violations is building an addition without a building permit. The property owner is working on it, but I have not seen a permit submitted as of yet. As of September 3rd, 2024.
Permit application?
Yeah. So it's my recommendation to give 90 days, if not a per diem of $100 and $100 administration fee.
Good morning.
Good morning.
If you could please state your name for the record and who you are in relation to the subject property.
MITZA LACROIX, and I'm one of the owners.
Okay. Ms. Lacroix,
Yes, LACROIX.
were you sworn in?
Yes, I did.
Okay,
earlier.
perfect. And I'm sorry, there have been people coming in, so my question is not to offend, but just to make sure.
I came in earlier.
Okay.
Did.
I appreciate that. Thank you. So it looks like the property still has violations and a permit application hasn't been submitted. The town is offering 90 days to come into full compliance, or a $100 per day fine, daily fine, will start to accrue.
Is that for the permit? Remember I sent you an email last month? And because I called and I spoke with Jeffrey and he said there was one in process.
At what date? Because as of September 3rd, 2024, there was no permit. So what date did you
No,
submit?
the permit has not done yet. It's in process, but we already submitted everything because that was the first step.
What date did you submit?
It's not me. Everything is being done by the contractor.
Okay. So once I get the permit information, then you can let me know. But if you don't have any information, then...
I'll check again today before I leave.
But ultimately, she is working on it. She knows she needs to get the permit. She's been diligent at working, but the project is pretty big. It's a whole addition. So I'm sure that it's taking long to get plans from the architect.
If I may explain.
Yes, I have a question. So the permit application, this is an after fact.
At the time that she was noticed of the violation, the
Work was
addition was being built. It's
Okay.
not completed. Am I correct on that?
Yes.
Because there was no windows. Right now it does have windows, so I'm not sure why it's being worked
From the
on.
time that you sent the notice, there was already a window. So
Okay.
if I may explain myself. So
Yes,
this
yes,
has
this-
been a very long case, and I don't know how much that's been taking time of me.
This is your hearing, yes.
So from January, so we had a contractor to come to do the job for us. And we explained to him that we want to do the job with a permit. My husband is a police officer, and I'm a professional myself. So we were like, we're not doing anything if we don't have the permit. And he said, oh, yeah, the person I'm working with, they handle all this, they're going to do it for us. And we were like, okay. And by the time, we didn't even sign no contract, nothing. The next thing, we come to the backyard, and then there was already foundation done. And then the next weekend, because I work in a hospital, so I go every weekend, so weekends I'm not home. And then we come back, there was already a hall come up. So we had no idea. So then we stopped them, and we were like, okay, you cannot continue anything until we get a permit. And then that started end of December, and we get a notice till end of January. So this whole thing been happening, and we were not able to come to the town hall to report anything. So when we finally got the notice, we were like, okay, stop, no more work until we can get the permit. And that's when he told me, oh, I cannot do permit. And I said, but that was the first thing we agreed on. If you have someone, like you working with someone that does permit, and then we can get the job done correctly. And he said, oh no, it's not me, it was somebody else. So he was gonna pay somebody else to get the permit. So I was like, how can you do something and then somebody else gonna sign the license for you? So it was a whole story. Later on, finding out that everything was wrong. And then we called him back and he said, hey, we have to work out something. Either you return the money to us or you give us half, but you're going to help us demolish the place because it has to start back over. Going back, looking for other contractors, of course, nobody will want to take a job that's already started. Inside was not finished, so everything outside was done, but inside was not done. So because there was electricity, there was the foundation was completely done. The wall was up, windows there. So from outside, you can see it's a whole place, but there's nothing in there. So no contractor. We got 5 contractors coming over. Not one person want to take the job. Not one person. And all they're saying, oh, you need to demolish. But we cannot do it. I cannot demolish a place. I mean, if it was like a small thing, okay. But it's too big for us to do, and we have very small kids. So we haven't been in the backyard for a while because of that work. So finally, we found someone around in May a contractor who finally agreed to do the job for us. But of course, for him to do the job, back to the plan, we actually had a contractor prior to that. I came here with it, submitted the plan and everything for the permit, but then they were asking him for other papers, and then he was looking like, what is it? So I'm like, okay, I don't need you. If you come to the town hall with me and you don't know what other documents you need for a contractor, then you don't know what you're doing. So I had to let him go and then wait until I got somebody else. So finally, when we found the one we're actually working right now, so he had to take his time. He had to go over the plan, come back to the city and find out like what was wrong with it and what's already there for them to demolish and things that we could save, because it was so much money that we had already spent and he didn't want us to break down everything and then for us to pay to restart it. So I got to the point where I told my husband, like, leave it alone. We're not gonna have the addition anymore. So he took the whole time. So it took a good 4 months for him to read everything, come to the place, see what they can save and what not save, for them to actually take over the demolishing part and to reconstruct it for us. So they finally had agreed to come up with a plan, have the engineer, like everybody that needs to be involved, had everybody involved, anything that, you know, that was missing, they called the engineer and they got on the same plan with the engineer. So finally we had that person working for us, and then they finally brought the documents about last month, and I sent an email to the officer. So I don't know what's going on. But before I leave here today, I'm gonna go ahead and see if the permit process. So it's not that I couldn't get in compliance, it's just there was no way I could have done it because I am not a contractor. I am not like a man, like I could not do any of the work that you guys wanted me to do. In order for me to get the permit, I would have had all this paperwork done and I could have not got done. And I could not demolish my place because I don't have the instrument to do it. Then I would have paid more money to even have a company come to demolish it for me. So to have to spend more money, I would have preferred just leave it until I get somebody that could get it done, and then we spend more money to just get it the correct way. So that's the only reason why it's been almost a year we haven't been in compliance. I'm sorry.
No, not at all. Thank you for your testimony. And so based on the testimony of Officer Ramirez and your testimony, it sounds like because this person probably was not a licensed professional to start off with,
Yeah.
he could not submit the appropriate permit application and procure a permit. You now have someone who is licensed and is taking care of the work. Getting back to the one question, the town is offering 90 days. And I just need a little bit of clarity. Your testimony is that your person submitted the application?
Yes, I called and I spoke with Jeffrey, and he said yes, they received everything and it's in process. It's gonna take time.
Okay, so the town is offering, just so you understand, 90 days for total compliance. Part of what I'm understanding from the testimony is that there's gonna have to be some sort of corrective, part demo and part,
Because the demolition is not done yet.
right. So they're offering you 90 days,
90 days for the permit or to
No.
reconstruct?
total compliance. And that's why I'm focusing on that part, because
Honestly, I don't know how long it's going to take because they will not touch anything until they have the permit. So from the permit, I don't know how long it's going to take for them to come in and demolish it, and then for them to, and then holidays coming. So I don't know whether they're going to tell me they're going to be on vacation and they're not going to be able to work. So I'm not sure if 90 days is going to be. I would have to speak with my contractor and see. And then that will be from the time that we get the permit, since nothing cannot start until the permit is there. And they're very strict on that.
okay, so I'm going to tell you what I'm inclined to do. I'm inclined to stick with the 90 days, just because this violation has been, going on, and we need to get, chipping away at coming into compliance. What I'm going to encourage you to do, as it seems like you're already doing, is to stay in contact with the town with regards to if you need more time, but you have to continue applying the needed pressure on your contractors once the permit is issued to quickly expedite this. Do you have anything else you'd like to add before I give oral pronouncement?
I guess. Can I have all my violation fees excused?
Well, once the property is in compliance, that whole history that you described with the initial person, you can apply with the town, put that in your application, and at that time, you'll come back before the special master, and the town will have a recommendation. But you have to be in compliance before, mitigation or abatement, which is why I strongly encourage you to continue working with your contractor, because compliance is the goal.
Madam Magistrate, if I may?
Yes.
Just in response to the respondent statement, the special magistrate's role is to review the testimony and evidence, review the city code, and then decide whether there is a violation or not a violation. The magistrate is unable to excuse violations. The magistrate is unable to change the city code or grant variances or take any other action besides determining if there's a violation or not a violation. If there's other avenues that you wish to take, you can still do so with the city commission. Only the city commission has the ability to change code, but is not within Madam Magistrate's authority to grant excuses or variances or otherwise exceptions to the code.
Thank you.
Sure.
Thank you, Town Attorney. You have anything else to add? Okay. Well, and let me just add, you being here and taking responsibility for the violations is great. Your testimony certainly add clarity. It's unfortunate that you dealt with someone who held themselves out to be a professional, licensed professional who could procure the permit when in fact they could not. And so all of these things at the time that you apply for mitigation once the property is in compliance. If there's nothing else from either side, I'll give oral pronouncement. Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a daily fine of $100 per day. Respondent is also assessed $100 administrative cost for today's hearing. And again, please stay in contact with the town and work with them.
Oh, here's my card. Thank you. I have it. I have it. All right. Thank you.
Thank you. We can call the next case.
Next case is on section 9.2 of the agenda. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 8742. Property owner Seneca Industrial Holdings LLC, care of Ernest and Young LLP. Site address 2601 Southwest 32nd Avenue, Pembroke Park, Florida. A notice of formal hearing to confirm fine was sent by certified mail September 6, 2024. However, the property manager requested a notice of hearing to extend time on September 17, 2024. It was posted to the property and town hall October 4, 2024. The violations are for installation of racks without a permit and installation of a wooden structure for a conference room without a permit. As of September 6, 2024, these items are not in compliance. Therefore, it is on my recommendation to give them 90 days to complete all work. And if not, a per diem of, let me see what we gave last time, $250 and $100 admin fee.
Good morning. If you could please state your name for the record and who you are in relation to the subject property.
Good morning. I'm Rena Adan.
Adan?
I'm the office manager for the property, for leased property.
Ms. Reyna, if we could just swear you in. If you could raise your right hand, do you swear and affirm the testimony you provide will be the truth and the whole truth?
I do.
Okay. So it looks like the property has some existing violations by the testimony of Officer Ramirez. The town is willing to offer 90 days to come into full compliance or face a daily fine of $250 each day you're not in compliance, and $100 administrative cost. What's your position with regards to that?
That would be acceptable. We're very close to getting everything finalized. We have been working with the town, responding to their comments. We have mechanicals, architects, fire contractors, GCs, so it's a lot of people in the pot to work with. We also have a permit expediter that I think has been forwarding all the information necessary to the town, to the building department. I think 90 days will do it.
Okay.
I do.
Okay, very good. As you've heard me state before, please stay in contact with the town and Officer Ramirez in the event that you will need more time, but you have to show diligence towards, as I'm sure you know,
Absolutely. I've got a timeline of things that have been happening, and it's 3-4 items a month, so it's diligently working on it.
Okay.
A lot of pieces.
Very good. Unless there's anything else from either side, I'll go ahead and give oral pronouncement. Based on the testimony and evidence presented, I find there is substantial and competent evidence to support the town's position as to the existence of a violation on the subject property. The respondent is hereby ordered to come into compliance within 90 days or face a per diem daily fine of $250 a day. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you.
Thank you.
You're welcome. Next case when you're ready.
Next case is on section 7.12 on the agenda. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 9982. Property owner Seneca Industrial Holdings LLC, care of Ernest and Young LLP. Site address 2775 Southwest 32nd Terrace, Pembroke Park, Florida. A notice of violation was sent by regular mail August 5th, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail September 6th, 2024. Posted to the property and town hall October 4, 2024. The violations are for item number 1, operating without a business tax receipt. Item number 2, outstanding certificate of use, renewal and fees. Item number 3, installation of a walk-in fridge without a permit. And item number 4, installation of rack system without a permit. As of October 10, 2024, item 1, 2, 3 have been corrected. The only remaining is the rack permit, which the contractor is working on diligently. So it's my recommendation to give them 60 days to come into compliance. If not, a per diem of $350, as this is considered a repeat offense. The final order was entered into the record of case 8742, and a $100 admin fee.
Thank you. Good morning. If you could please state your name for the record and who you are in relation to the subject property.
Julian Donato. I'm here as proxy for Alan Grobman, who's the building manager.
Okay. And Mr. Julian, I will need to swear you in. If you could raise your right hand. Do you swear and affirm the testimony you provide will be the truth and the whole truth?
I do.
Okay. So it looks like, based on the testimony and evidence presented, that there's one item pending with regards to the items cited in the violation. The town is offering 60 days for everything to be completed, or face a daily per diem fine of $350 per day, as this is a repeat offense. What's the position with regards to that?
I think 60 days is fine. Would request an additional 30 if possible, just because we have faced challenges in the past with getting these permits. And as someone stated earlier, we are going into holiday season, so we have historically learned things move a little bit slower around this time of year. So if we can get an additional 30, we'd be very
What's
grateful.
the town's position?
This is okay.
Okay. Okay. The town's in agreement. Anything else from either side?
That is all.
Okay, perfect. Thank you.
Thank you so much.
Based on the testimony and evidence presented, I find there is substantial and competent evidence to support the town's position as to the existence of a violation on the subject property. The record does reflect that this is a repeat offense case number 8742. The respondent is ordered to come into compliance within 90 days or face a $350 per day daily fine. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you.
Thank you very much.
You're welcome. Thank you. We can call the next case.
Next case on section 7.9 on the agenda.
7.1. I see more bodies than are listed on my sign-in sheet. Yeah, yeah. Other than Mr. Julian, because I know we had a few people that came in after we began. Thank you for being here and welcome. If you could please raise your right hand so you can be sworn in. Do you swear and affirm that the testimony you provide will be the truth and the whole truth? And out loud, I do. I do. Okay, thank you. Okay, perfect. We can call the next case, 7.9.
Yes.
Okay.
Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 9839, property owner 3200 Realty Corp. Site address 3200 West Hallandale Beach Boulevard, Pembroke Park, Florida. Notice of violation was sent by regular mail, July 16, 2024. Notice of formal hearing with a copy of the notice of violation was sent by certified mail, September 6, 2024. Posted to the property and town hall, October 4, 2024. The violations are: item number 1, Henny Wings and Tings food truck is operating without a business tax receipt. Item number 2, there are 2 flagged banners on the property, on the food truck. As of September 5th, 2024, both items are not in compliance. And I believe there has been some trouble with the fire inspections. So it's my recommendation to give them 60 days to correct all violations. And that would be for the BTR. But the flag banner should be removed as soon as possible.
Okay.
If not, a per diem of $250 and $100 admin fee.
Good morning.
Good morning.
If you could please state your name for the record and who you are in relation to the subject property.
My name is Sabrina Singletary. I'm the owner of the trailer, food trailer.
Sabrina?
Sabrina Singletary.
Cybrine? Good morning, Ms. Cybrine. So you've heard the evidence and presentation, and the town is offering for the business tax receipt 60 days for you to come into compliance with that. However, as to the sign violation, the flag banner, that the town is asking for that to be removed immediately, or face a $250 per diem fine. What's your position with regards to?
I accept that the flags has been removed. Okay. And concerning the permit, the certificate of use, the fire inspector said I needed a permit for the fire suppression.
Okay.
I went and got a fire suppression, but he said that I need a permit. I called City Fire, asked them for the permit. They said they don't do permits for trailers, for food trailers. But they did it for me, and I did submit it to the Jeffrey this morning. They submitted it this morning.
The suppression.
The permit.
Okay.
The application for the permit for the suppression for the trailer.
So you will be able to get that?
Yes.
Okay.
Fine.
Okay.
Can we put this on a brief recall for a second?
Yes, we can. And I'm going to have a question also.
Okay.
Madam Magistrate, thank you for the additional time. We're going to ask that this case just be continued so we can look into it a little bit further.
Okay, very good. And for the record, this is case number 9839. The town is seeking for this case to be continued
Yes.
until reset.
Until reset.
Any objection?
No.
Okay, very good. All right.
I'm sorry? Right. So we will send it by certified mail.
So when this case, if and when this case is renoticed, you'll get notice in the mail. Okay, good luck to you. Okay, so that's noted on the record. This is the next case? Okay.
What case are you on? No. You're just here? Okay.
7174, I
Yeah.
think.
So that's section 8.5 on the agenda.
Okay.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7174. Property owner Pembroke Park Church of Christ of Broward County, Inc. Site address 3707 Southwest 56th Avenue, Pembroke Park, Florida. A notice of formal hearing to confirm fine was sent by certified mail September 19, 2024. Posted to the property and town hall October 4, 2024. It is the town's motion to confirm the fine of $182,100. This has accrued for 728 days.
That was $182,100?
Yes.
Okay.
And the only item pending to correct this violation is commercial AC changeouts were installed without permits. There was a permit pulled for it, however, it's expired, so it needs to complete all the inspections, and I believe they have to reapply for a permit now.
That was going to be my question. Okay, thank you. Good morning. If you could please state your name for the record and who you are in relation to the subject property.
Good morning. I'm Patrick Brinson here on behalf of Pembroke Park Church.
Okay. Hello, Mr. Brinson.
Hello.
So it looks like the property is still not in compliance, close to full compliance, as the commercial AC changeout, that still needs to be complied with. The town is seeking to confirm the fine, which to date is $182,100.
This is kind of the case is not news to us because we've been working on it, but it's news that we're here today. We received the notice and it didn't have anything, it didn't reference anything. However, when it comes to the AC, we've always had permits. These permits were held open the AC changeout was done in conjunction with the roof years ago. And of course, the city has the new screening ordinance. So the screening part is what has held it up. And even in the first place, they were not connected. So they never should have been held like that and have, so many days going on. But we finished the screening project and I received the final inspection a couple months ago. And we've still been waiting for a disposition from that. So that's kind of what's holding things up. So I'm not sure what's going on. And even in between that time, we've not received any correspondence about, something like this coming into place, or I'm not sure if you guys send other notices, like say, hey, in 30 days from now, you're gonna X, Y, Z. But in my opinion, or what I thought, I was under the impression that everything would have been kind of, winding down, or definitely not have gotten to this point where we're at the hearing today. But I'm open to see what we need to do. But we're definitely have been in compliance per se.
Okay, thank you for the testimony. I do want to deal just to make sure the testimony of the town and the evidence presented and a review of the file. This original violation dated back to June of 2022. And so that was stated in the presentation of Officer Ramirez. Before we get to this part of the code enforcement process, an order would have been issued giving the respondent a certain amount of time to come into compliance. And the testimony shown doesn't reflect that's been completely achieved, as there's a single item. Also part of the testimony is that, and I believe your testimony supports this as well, is that permits were applied, but at some point in time, it looks like they expired. Permits do expire if work isn't completed, inspections aren't called. And so I'm not sure what happened. And so to the extent the permit that was applied for the commercial AC changeout has expired, that needs to be reapplied for and reissued and then worked on and then called for inspections, all of that. But with regards to the fines, and Officer Ramirez, was the daily fine $250 or was it?
Yes.
Okay, so from the time the property was issued, or the respondent was issued a final order to now, or expiration of the time to comply, it's been over 700 days not in compliance, which is how the total amassed to $182,100. And so today's hearing is to confirm that amount and also to apprise the respondent that the daily fine is going to still continue until the property is in full compliance. So to that extent, what the respondent is encouraged to do, as it looks like they've been doing with regards to the prior or the other existing violations, is to bring this last portion into compliance, call for inspections to confirm that it's complied with, and then the respondent, once it's in compliance, can apply for abatement or mitigation of the fine and lien.
Yeah, because I definitely was not apprised to the fact that the fine had gotten up to this amount. We always knew that there was a fine in place. Excuse me. But as far as, that amount, it definitely is definitely over the top. If, Officer Ramirez, right, we've definitely been in contact through the years doing different things, but it goes back to the fact that we have a roofing project and we have an AC project and everything is permitted, everything gets done, final inspections through the city and the fire department and everything's there. Then you guys hold open from closing out the permits because of a new ordinance. And so I just think that's something else within itself for us to look at, because that's fine if the city has an ordinance that they want to have the screening. I mean, even our building, I thought it was definitely a little asking, more of the church to have something screened when our building sits, a couple of 100 yards off the street, and you can't even see it anyway. But I get it. It's an ordinance. We're considered, a commercial building. So we did just that. And if you could imagine the costs associated with trying to do this type of screening project is really exorbitant. In addition to that, we have been involved in a pilot agreement. There was, many things that's been going on over the years, and we have complied with that stuff. And so to be at a situation right here and definitely trying to confirm something of that amount is I don't think it's the fair, I guess, is the word. But even leading up to this point, because when it comes to the permitting and stuff, the only permit that I know of that had expired was the screening permit that we applied for. And then, once we got with an architect and got everything approved and got into the city and got the approval, the permit was approved, but we hadn't picked up the permit. So usually with most cities, when we come and we pay for the permit and we come to the city, it gets issued, and it gets issued on that day.
Mm-hmm.
So, because, any permit can get approved right now. It's not supposed to start a clock from the day it was approved, because sometimes, there are many things that go into the approvals, and sometimes you don't even know. So basically that's what happened with this. And we ended up having to pay, a substantial amount again, once we came to get the permit to have to renew it. So it's all of these extra things that the church, when already being a nonprofit, not having, to just a bucket of money to throw stuff at, it's been a big burden on the members of the church having to try to, to pay these things. But when it comes to that fine, I don't know what and when the amount was daily accruing. And but again, we knew that there was going to be something, but hopefully we will be able to, get it abated or whatever way, because it's definitely not fair on the church to have to. Everything has been in compliance when it comes to putting the permits and getting it done. But there's been on the paperwork side, there's been some, discrepancies within that.
Thank you for sharing that testimony. And so with regards to the last component, I would strongly encourage you and the church, and particularly the hired professional contractor, because ultimately that would be the person who would have the information and the experience with dealing with permits, because the permit expired. So
Which one are we speaking of?
this is the Officer Ramirez, this was the permit for the AC change out.
Yes.
It expired. So, and I'm presuming that the church used a professional. But I say all that to say is that that's the only item that's remaining for full compliance, so that that can be confirmed. And then, and by confirmed, I mean Officer Ramirez can say, okay, it's in compliance, here's the date of compliance, and then the church can apply for mitigation. So, after today's hearing, you definitely want to get with the hired professional or the professional who is handling the permit side to get that in compliance.
That's myself.
Oh, okay. So yes, so if you have time after today to visit the building division, to sit down with one of the, or make an appointment, is what I would recommend. But once the property is in compliance, you can apply for abatement. Unless there's anything else from either side, I'll give oral pronouncement. Did you want to add anything else, Mr. Patrick?
Well, yeah, I mean, there's, until recently, this is the first time I'm hearing anything about the AC permit itself being per se expired. Clearly we put the ACs in years ago. However, because of the ordinance for the screening, and you guys put everything on hold for us to, wouldn't close it out. Like I said, that's a whole other thing, like holding this for this to be in compliance. And clearly, I would imagine we had to get the AC project done, and then they said we would come back and everything gets closed out. So it seems like now we're being held back because of something else that, clearly can't be, current right now because I think the ACs were done like, I want to say over 5 years ago or so. So, it was never a thing of the ACs itself and that permit because, again, it was a special situation and because of the entire building project that we had in place that we were doing. So we had a whole master, permit for, work being done and things like that. And so now to get to this point where the screen itself is quite absorbent, another exorbitant cost, and now we're saying that, oh, we're not in compliance because of the AC. I mean, and again, I understand getting the AC renewed and getting done, that's not a big thing, but I hate to, me having to explain back to the church what's what in the show where, okay, well, now we're not in compliance because of this. That's kind of, well, I mean, I digress, but
No,
it's,
no.
it's, as long as it can be addressed and there's going to be something else, because there's no way I can, even now going back to the church, to telling them that there's a, confirming 100.
Madam Magistrate, if I may.
Yes, Attorney Sherman.
So, briefly, and not providing, of course, legal advice to you, but as far as generally applied and without knowing additional information, when you have a permit that's expired and you don't have the final permits, well, that, of course, is gone. Then at that point, it's considered unpermitted at that point. So when it becomes or you renew the permit, then it's within the discretion, or really it's you have to bring it up to the current code. So that's where, as far as the difference, if everything was completed at that time and inspected, then there might be more credence to what I think you're saying here, where if it wasn't required then, why is it required now? Well, because technically it's unpermitted. You have a permit, but again, anyone can pull the permit until you get the final inspections to show that you complied with the permit. Then at that point, the permit expires. So now that you are permitting it or bringing it up to date, then you have to bring it up to date to all codes. So
But it was final and everything. We received that final. So administratively, the town didn't close out the permits because they just put a hold on it, basically. But we received every inspection. We received our rough inspection, our final inspection.
Like I said, if there's any additional information you can give, but again, it's the records presented are the permits expired. So
Officer
We will
Ramirez.
have to look into it because there's no evidential support of that right now. There's no documentation to support that. If that were to be true, then that would have to be a conversation we have to have with the building department to see if it checks out. If it does check out, we can always backdate from the time it is in compliance. But if not, the permits do have to be completed.
Mr. Patrick, did you understand that?
No, 100%. But yeah, they're definitely, we received, like I said, I was a contractor, licensed general contractor, roofing contractor, and over 20 years, I understand what goes on. But we had every inspection. I was there myself with the inspectors, and we had a fire inspection, everything. But again, there was an administrative hold put on after the fact, and then that's why we're going. And again, we didn't have a problem with it because we understand that you guys wanted to accomplish a certain thing. We didn't think it would be this long and drawn out, and then definitely didn't imagine that we would be trying to be held accountable to this extent. But I'm open to look at it. Again, the paperwork is there. It's not, it's, it is what it is. It's there.
So all the notices do go to Pembroke Park Church of Christ, and they are posted to the property. So I'm not sure who is the person receiving the mails, but the mails are being sent.
And additionally, as far as the screening requirement goes, it's different than as far as the building code. That's in the city code, correct? The screening is in
It's
the
a city ordinance.
So even additionally, because again, what I was saying was going towards the building side of that as far as permitting, not permitting, but the actual, depending on the code, that applies to everyone as far as the screening is concerned. There's no grandfathering in, generally speaking, without looking into it further. So that still applies. So even that may not excuse you from it. That would have to be looked into further as well. Same way that as far as, let's just say that there's certain aspects where there's no again, to say that way is the correct way. I was looking for an example. I just can't think of one quickly on my head. But as far as if there's not any type of grandfathering provision, then it applies to everyone equally as well, even now going forward, not necessarily under the building code, but again, under the town code. That's something that I can discuss with code separately.
Is there anything else from either side?
Is there, so with that being the case and with their, is there a way for there to be, for lack of a better term, a stay on this or for this to be held off? Because I'm not even sure, like I said, with not having legal advice, the implications of going forth and agreeing to something like that being even in place. I wouldn't even want something like that being on record with an exorbitant amount like that, especially with all the things that have been presented and where this I believe is going back from like 2012, I believe. And so for us to come and be at this point and then to confirm something like that of that magnitude is, I don't think it's.
No, I understand your statement. My first question to the town is, would the town have an objection? It sounds like Mr. Patrick is asking for the fines not to be confirmed. Is there an objection to that request, if I'm surmising what you're saying correctly?
Yes.
This has been ongoing since June 22, 2022. And initially, there was a notice of violation by the former building official, Alan Correville, back in May 10, 2017, regarding the installation of AC units. This just has been an ongoing situation. And I think we have sent notices and it just fell through the crack many times. So I would like to move forward to confirming the fine.
Madam Magistrate, if I may,
Yes, Attorney Sherman.
the prior order, when was the prior order entered, if I may ask? So the prior order finding the violation has been in existence obviously for 2 years at this point. And for the record and for the gentleman, so a finding of fact has already been made. And of course, the town is always willing to look into this additional information, to look into anything that's there. And also, you know, when the actual ordinance was passed and everything else. But at the end of the day, we're happy to look into it. But legally, we do have a prior order that is final and is on record. So the only decision for you here today is to say to confirm the fine or not confirm the fine, which would either put a lien on the property or you would continue the case. But again, the prior order remains in place and it is not altered or changed by this hearing unless so ordered, which again, the town is not requesting. So that's what is before you. So it's just a confirmation of final, whether there's still a violation or not a violation as far as compliance is concerned. And the testimony before you is that it is not complied.
Thank you, Attorney Sherman. Yes, I am aware for both parties that the purpose of today's hearing is to confirm the fine. But based on the request you are making, obviously the city is here to confirm your fine. And so your question of holding off on confirmation, I have to weigh on both sides before I give a pronouncement as to that request. So I am not in agreement with staying the confirmation of the fines. What I do want to summarize as to the testimony from both sides presented and edification by the town's attorney with regards to points that you raised in your testimony. The record reflects that a final order was already issued approximately 2 years ago. Generally speaking, at a confirmation hearing, we're really asking two things. Is the property in compliance? And if it's yes, when was it in compliance, to confirm that date, to have a sum set amount. Part of your testimony with regards to the accrual of the fines is that midway there was a change to the ordinance. The town attorney, Attorney Sherman, apprised you that if, as the record reflects in the testimony presented, the permit regarding the AC expired. And so technically there would be no permit and therefore a violation would exist. And as a point of law, if you're not in compliance and the law changes as to a particular code provision, building or city or county code, you are now subject to the new regulations unless there's grandfathering or an exemption or some sort of provision that carves out a particular segment of properties or permits, et cetera, from not having to comply or giving a time period to meet the new requirements. But that's not the subject of a hearing to confirm the fine here today, which is what the town is saying. Now, part of your testimony indicated that the AC permit was already finalized out. You don't have evidence to support that. However, the town is willing, if you present that, to backdate if in fact inspections were called and it's noted that the compliance was achieved.
Just briefly, we're willing to review. I don't want to make an agreement based on if-then statements, but we're happy to review any information, and then we'll act accordingly. I don't want to put an if-then as far as an agreement on the record, but no, but we're happy to review fully.
Oh, okay. And I'm just summarizing part of the testimony of what Officer Ramirez said. You're saying, and this is on the issue of, it shouldn't be 182,000 because we came into compliance way before. I'm summarizing my understanding. And if that is the case, and you have evidence that supports that, you need to present that to the town. And to the extent that that's accurate, the town will address that accordingly. So I don't want my summation to be I'm not testifying, let me just say that, and what I say is not testimony, but just so we can be all on the same page without the legalese.
I feel confident in saying on for Ramirez that the town is always willing to review, and we're here for the residents, so we understand.
Right, because as to that component, you're saying 182,000, how did we get here? I was already in compliance. So, but you don't have evidence to support that statement. And so there's no record evidence at this hearing for that. So you can address that with the town. My oral pronouncement, unless anybody has anything else.
Well, yeah. So I guess my question is, how does this affect the church per se when it comes to this being confirmed? Does it affect our ability to go back? And because again, I don't want to ruffle any feathers. It's just, as long as like this doesn't affect us negatively to where we can't address some things. But if you're saying we can go back, and if in fact, of course, clearly, I mean, I figured we would be able to pull up the records. No records are coming up as far as inspections with from the church. I figured that would be easily able to pull up with the records.
The only record we have is a permit that is expired. So that's number 177171-0.
And when you say the only record, are you looking at the inspection records, or you just looking at the permit itself?
The permit with the inspections, that permit is expired.
No, I understand that, but do you see the inspection record? Do you show where we've had our inspections and that it had a final inspection, or does the system not have that?
Yeah, you can review it in the system.
No, I know you can. I'm saying, do you see that? Because we're saying we don't have the information. I'm saying it takes a couple of strokes, and if you have it up,
So are you
does it show?
You're requesting a public record. You don't have it with you? Like, you never had that document with you?
Well, no, clearly, I mean, today I didn't even know. The letter that we got said that there was a hearing today.
Right.
And it said our address. So I think even within that, for it not to, to reference it, that's fine. What I'm saying is that we're saying we don't have anything. So is that something I would have physically had to have it sitting here? Or?
And Mr. Patrick, I don't recall if you were here at the beginning, but at these hearings, any evidence or exhibits, anything that you have that supports your position, you're always welcome to bring that. So do you have a date as to when a building inspector went out and said, okay, this is all clear, this is all done according to the permit? Do you have a date?
Approximate, I would say that would have been back in like 2017, in the year 2017 when this was done.
Madam Magistrate, if I may.
Okay.
I believe what the gentleman is trying to ask is there anything that Ms. Ramirez can see today here that supports his position? And I believe the answer to that is no. But with that date, she's going to look again
unless the
See what we
system-
have, but again, it's you can make a request of the records, show everything that we have. Again, she's reviewing it as well. And
Yeah, because I was going to look at my stuff too. I especially, is it that it's a new system and it doesn't have it? Because of course, we have inspections every day. We have, I mean, not us per se. I mean, in general, if we pull up a house, it just shows there was a roof and it had a rough, it had a tank cap inspection, the final. And, you guys have a pretty
Systems
decent
change.
system, but I figure if it changed, maybe it wasn't all uploaded. Because again, this permit was from 2017. And again, just to recap, it's just so outlandish thinking of how we're here because we've in compliance to the letter. I get it because if something expires, then technically you're out of compliance. But what I'm saying is to the fact that there's been so much going on with the building project and everything. We've always have permitted. We've always had inspections, and even up to final inspections. And then it got stopped because of the new ordinance. And we even were talking and having meetings about whether or not we would have to do it because, of course, the church was built in '92 and everything's in place and it sits back way off the street. So to have us go through and pay another $50,000 or more in order to screen this for something that's literally, back. I'm not sure if you're familiar with the Pembroke Park Church and how it sits, but it's so far. No, the purpose of the ordinance is to not have like an eyesore, for the units and have some type of decorative screening there. Mm-hmm. But if you can't even see it from the street, but they decided, hey, they want us to do it, and we did that. But we've always had our permitting. We've always had inspections when it came to the screening. Even like right now, we got the screening permit and it's been in place. Like, why should there be fines accruing for a project that we have to do and it's permitted and it's in place? Like, who knows? The project can take us 1 month. It could take us 6 or 7 months because, again, it's quite a bit that goes into the fabrication and stuff of the stuff and then the installation of it. Mm-hmm. And then for it to be in compliance with the hurricane wind loads and things like that. But even along those lines, I called for a final inspection. This is August, I believe, 17th. We had the inspection, and I still haven't yet received the disposition. So whether it's because I'm not sure what it can be that the city is doing that they couldn't finalize that inspection. So now this is 2 months.
If I may, forgive me, sir.
No problem.
I don't mean to interrupt you, but again, that's exactly what I'm doing. What we're doing is Ms. Ramirez is showing the respondent exactly what we have in the system. It shows that there were a number of inspections. Some were canceled back in 2017. And ultimately, the project wasn't finalized. And again, I know the respondent's looking. I want him to be able to hear again because the original order is still in place. We're not here to litigate or relitigate or have an appellate hearing of the original order that became final in 2022.
Cancel again. Cancel.
Pass.
Right, but
final.
So, and it's different from what you see on the screen here. Is different than what he's showing us the actual record, which again we're submitting for the record.
Do I need to? Does it matter?
It's up to you.
So,
you can feel free to have a conversation, but whatever's on the record is what.
No, 100%. So those are just inspections that go. I mean, sometimes you have where you just pass an inspection right away. But of course, today we have an inspection. It could be rain, it gets canceled. It can be I'm not there, it gets canceled. That's fine. Yeah. But you have several of them down the line. It gets passed. We had electrical, it got failed, and then it came back, it passed. You have mechanical, the rough failed, then you come back, it passed. Then we have another final, then it either pass or fail. But you have all of those passed in there because we get to a point where it's passed and we get to the final. So I guess I'm not sure how much you understand with the building department and stuff, but
I do. But again, the testimony is that ultimately between all the different parts of this permit is that the ultimate every aspect of it, it wasn't fully final for the actual permit. Parts might have passed, but parts didn't. And that's what the record reflects. But again, that was the order from 2022, which was already found at that time. So the order finding the violation that was already made and has become final. So that order is there. Here, we're here for the confirmation of fine. But again, I'll let Ms. Ramirez address the rest.
So,
Because fines have been running since that original order in 2022.
and they shouldn't have even been the case. And
No, I understand your position.
I didn't
That's
even
where we're-
really 100% know that was.
So that's what I'm showing in the system, unless there is something else that you know about, then that way we can review it later, but that's what's showing on my end.
Yeah, I guess for us to sit here now and try to go through it unless that would be the line of action.
And for the record, Mr. Ramirez, if you can just list the permit and the city's records, although they're electronic, we're submitting them for the record for this particular hearing, which was reviewed by the respondent as well as Ms. McKinney.
That's permit 177171-0.
Thank you.
And yeah, so going down through those lists, we have several inspections that were called, some were passed, and then some did not pass, were canceled. That's a normal thing for a project, especially on a large project. So, but each one of those, it goes down and I see passed, canceled, passed, failed, passed, because it could be, if the inspector comes up and there's one thing that needs to be addressed, everything is done and is right, but he's gonna say, hey, move this vent over here, you know, a couple inches, or move this fire damper or whatever. Of course, then we recall the inspection and then we pass it. So it's not a case where something is just altogether wrong or there's some big a situation. It could be a smoke test. It was one of the days that we had a smoke test and the weather was bad. So of course it was canceled. So there were many inspections, and those it's there in the record. Eventually they were passed. And if we go back and look at each one, the electrical is passed, the
Right.
fire is passed, and we get like all that stuff
We
is
don't deny
done.
that there are some inspections that would pass, but all of the inspections have to be passed, and there are some that were canceled, some that were failed.
Right. And
So everything has to be passed.
correct, and that's the city's position. And if you could, again, accept the city's file as well as the permit records, at this time, the city has nothing further to present.
Okay. And so even with that, the statements about all of them not passed, that's still misleading, because basically everything is leading up to it is passed. The final inspection, when there's a final inspection, basically you can't call the final without passing all the other sub permits and sub trades. And they're saying, hey, the building official or the building inspector is going to come and just do his final walkthrough. Everything's at this point is closed up. There's nothing to inspect. They're going to make sure that it's on, and aesthetically everything is cleaned up and everything's done. So again, to the point of it being closed, the permit being closed as in they give that final disposition, that's not the case. But when it comes to the work in place, everything is done, and there's no situation where even through a code change where we would be required to change anything, because the work itself and all the subsequent trades have been passed. So now we get to this point, and I can say, I guess on record, I definitely did not know that. Well, may I ask, how much is the fine that's being accrued?
Well, right now, to date, it's $182,100, and it's continuing to accrue. I would like to go ahead and
No, as far as the amount, if I could, like, how do we get to, like, how much is this per day or per what?
this is a $250 per day fine, $250 per day.
$250 per day.
But I understand both sides' position. I do want to give oral pronouncement. I do want to go back to this particular hearing is to confirm the fine. The record does reflect that a final order has already been issued approximately a little over 2 years ago. And so with regards to what I'm hearing is the contestment of this accrued fine amount as it relates to the one pending item with regards to the commercial AC change out that's still not in compliance. Whatever items are listed on a particular permit, all things need to be finalized. And so that's a discussion to have with the building department. I am going to confirm the fines. I'll give the oral pronouncement. I am going to recommend that you, since you're handling the work, to contact the building department to get this last item complied with, and then you can apply for mitigation. And because really all of what you're stating, the procedural history, you can put that forward with regards to your mitigation request, because the finding as to the existence of a violation has already been rendered back in 2022. My rendering finds that the property is still not in compliance. So to that extent, based on the testimony evidence presented, there is substantial and competent evidence to support the town's position. The property to date remains not in compliance. The confirmation of the fines will be confirmed. The amount of the fines confirmed today is $182,100, which shall continue to accrue at $250 per day until such time as this case is in full compliance. Respondent is ordered to correct and comply. Administrative costs of $100 are assessed for today. What you need to do, Mr. Patrick, is to reapply or submit a permit application anew for this one last item, and work with the building department to get that inspected and completely all inspections passed and finalized, and get that date and contact Officer Ramirez, and then you can follow the town's procedures for filing a application for mitigation.
So any issues that may exist because of, like, say, something on the town side that may have prevented us from, say, having it final, say, today or last week or last month, that's something that I just need to just go and deal with now? Aside from that, does that have any bearing on right now or on the ruling today?
Well,
Because-
my ruling today is based on the evidence and testimony presented. And just to clarify, today is not the day to appeal what happened 2 years ago, or to re-argue, or to argue, or to relitigate that.
Okay.
There's already an order in place that found this property in violation, and that order gave the respondent a certain amount of time to comply with all violations. We're not here about that order. And normally, I don't allow, or, the extent of testimony, and I'm being for it because this hearing is just the confirmation of the fines, which is why the town presents the testimony and evidence as to what is still pending and holding a case not to be in compliance, and everything. And so you've presented your testimony as to why that is, and that's on the record, but my rendering and decision is based on, and you'll recall I said there's 2 questions at a confirmation hearing. Is the property today in compliance? And if so, when did it come into compliance? And what is that amount we're confirming? The testimony and evidence in today's case reflects that the property is not in compliance, and therefore confirmation of the fines are confirmed based on that testimony and evidence. And furtherance, the daily fine is going to continue to accrue. You want to go back to 2 years ago, but that's not the purpose of the confirmation hearing and such. Now, part of what you put on the record in your testimony is that, oh no, we were in compliance on this date, but there's no evidence, right, that supports that portion of your testimony. Again, further establishing that the city's request to confirm the fine is presented by substantial and competent evidence to do so, and supported by the record, just so I can, clarify, so you can understand the purpose of this hearing. A final order was already issued 2 years ago, and the fines have still been accruing. And so that's how we get to the 6-figure amount. But you will be able to submit an application for abatement or mitigation once it's in compliance.
And so whether or not it's in compliance today, does that have a effect on the ruling today or not? Does that have any type of weighing on it? Like, say, if we were in compliance, does that change anything?
No, but my ruling to confirm the fine finds that to date the property is not in compliance, right? Because what you're presenting is contesting the actual existence of the violation. that's not what this hearing is for. This hearing is to say, okay, has the respondent complied or not? And the testimony and the evidence supports that and shows that it's not in compliance. And part of what you're saying is it was in compliance, or no, that's incorrect. I got a final inspection, but the evidence doesn't show that, right? As to like the amount we were in compliance way back when. There's no evidence to even support that, which, based on the testimony and evidence presented and my ruling is based on the evidence that has been shown that to date, the property remains out of compliance.
Okay. And my question was, does it have an effect if we were in compliance right now today? How does that affect today if we were in compliance?
I'm gonna interpret that question as a hypothetical. I am an attorney. I'm not your attorney or the town's attorney or anyone in this room's attorney. And so I can't answer that.
Okay.
My ruling is based on evidence and testimony presented, not on hypotheticals.
Okay, so sorry about that. No.
And that's why I said, you said it was in compliance on this date, but there's no evidence that you've shown. And the town has said you can discuss any evidence or anything you want to show them, and they will look at it. You don't have that here for me today. And so, again, based on the evidence and the testimony provided or submitted and shown, there is substantial and competent evidence to support the town's position in confirming the fine, because the property to date remains not in compliance.
So the reason I asked that, and if the question would be, so when a property is in compliance, what effect does that have in this hearing?
May I, Madam Magistrate?
You may, Attorney.
As far as this hearing, again, Madam Magistrate made a ruling. Once you're in compliance, then at that point the fines stop as of the compliance date. Then you can seek mitigation of those fines with the town.
Okay, because I definitely would request that the fine stop, because one, with the amount of information that we have and the discrepancies and stuff and how we got to this point, but even with the AC part, that's a whole nother thing. My thing, I was referring to the screening, the ordinance, which got us to this point, which is why I thought we were not in compliance because of the screening project. And I had a final inspection myself 2 months ago, and I'm still waiting for a final disposition. So all I'm saying is that,
Leslie, there's someone at the door.
all I'm saying is that that's at least 2 months of fines that shouldn't be there, and it definitely shouldn't be going forward past this day.
Once it's in compliance, that's the date. If there's evidence as far as an earlier compliance date, the town has reviewed in the past and agreed to earlier compliance dates when the evidence supports that.
Okay.
So that's the answer I can give you today.
Okay. All right.
You'll get a copy of the order. And of course, please stay in contact with the building official and also Officer Ramirez, so that once the property is in compliance, you can then apply for abatement.
Okay.
Good luck to you.
Thank you.
¿Le explicaste? Sí. I will give you a copy of your order, okay?
Nasli, is that a respondent? The lady? Okay.
Let me see if I can get staff to translate, okay?
Okay. We want to take a recess? Or?
It's up to you. Madam Magistrate, if you'd like to take a 5-minute recess, I guess the city would be in support of that. Obviously, we don't miss Ramirez.
Okay. 5-minute recess in case anyone needs a beverage break.
Hi, good morning. You can just stay up there. Actually, you could come here. Just put her name. Pon el nombre. 8315. 8315. You can say it. Okay. Heavy chair.
Okay. Do I have time for a restroom, or we're gonna continue on? No. You can go without me.
This is Martha.
Martha,
Good
pleasure.
morning.
This is our attorney, Brian Sherman. Attorney, Andrea McKenzie. She's new in the building department.
Pleasure. What are we addressing?
Okay, we're back on the record.
We're on section 7.2 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8315. Property owner Rose Esparatiz Perez, site address 3100 West Hollandale Beach Boulevard, Lot G9, Pembroke Park, Florida. A notice of violation was sent by regular mail, March 20, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, September 13, 2024, posted to the property and town hall, October 4, 2024. The violations are for item number 1, installation of an addition without a permit. Item number 2, installation of a shed without a permit. Item number 3, installation of canopy without a permit. Item number 4, extended carport without a permit. Item number 5, outdoor storage at premise, remove miscellaneous items and store inside. As of September 11, 2024, the addition has been removed. The canopy has been removed, and the outdoor storage has been removed. Only 2 items remain, which is the permit for the shed and a permit for the extension of the carport or removal of the carport. It is my recommendation to give 60 days, if not a per diem of $100 and a $100 admin fee. Now that I presented the case, I'm going to let Martha translate that.
Okay, to her?
Yeah, but you can do it.
Okay.
If you could please state your name for the record.
And does she need to be sworn in?
Yes.
Okay, so raise your right hand, and she's going to swear you in.
Can you state your name for the record?
My name is Marta Santiago.
Ms. Martha Santiago, do you swear and affirm that your translation from English to Spanish and Spanish to English will be the truth and the whole truth?
Yes, I do.
Okay.
We need to swear in the witness as well.
Do I just tell her?
Can
what
she,
has?
Ms. Martha, can you ask, what's her name?
Rose Esparati Perez.
Yes, if you could ask Ms. Perez to please come forward so that we can swear her in.
Señora Pérez, si puede pasar adelante para que le hagan el juramento.
And if she could raise her right hand.
Su mano, si puede levantar su mano derecha.
Does she swear and affirm the testimony will be the truth and the whole truth?
Y si jura que su testimonio va a ser verdadero y solamente verdadero.
Yes.
Gracias.
Thank you.
Thank you.
All right, so she's going to explain what I presented. Okay.
Ok, ella le explicó que usted tenía varias violaciones. Violación de una adición, violación de un shed, o sea, una casita. Extendió un carport, o sea, también hizo un carport y lo extendió sin permiso. También explicó que usted había ya eliminado she eliminated the addition. que usted había eliminado la adición y que solamente le hace falta el permiso para la extensión del shed
Y el carport.
y el carport. O sea, para el carro, donde va a poner el carro. La recomendación es, how many days?
It was 60 days.
Tiene
per
una
diem of
recom-
250. I mean, sorry, 100. Per diem of 100.
My notes. Yeah.
And
60 days to fix it, or usted tiene le han dado una recomendación a la Special Magistrate que tiene 60 días para completar el trabajo, ¿ok? Los permisos, y serán los permisos, o si no, después de 60 días tendrá un cargo diario de $150.
100.
Oh, perdón, $100 diario después de los 60 días.
Y $100 de administración.
Y $100 de administración.
Thank you, Ms. Martha. Ms. Martha, can you ask her to state her name for the record and who she is in relation to the subject property?
Sí, ella quiere que usted diga su nombre completo y cuál es su relación con la propiedad.
My name is Rose Perez. Is owner.
Okay. So she's heard the town's position. There are 2 items that compliance, and the town is offering the 60 days or face a $100 daily fine. What's her position with regards to the violation and what the town's offering?
Ok, entonces le ofrecieron los 60 días para corregir y $100 por día después de eso. ¿Cuál es la solución que usted tiene para esta violación?
O sea, si no quito el shell en 60 días me dan para...
She submitted a permit application for this, or no?
As of September 11, 2024, these items are not in compliance. I'm not aware of any permit application that has been submitted or anything. I just know that the property owner has been trying to get the permit. I don't know if she's been successful.
Ok, ella explicó que desde el septiembre 11 del 2024 no ha sometido una aplicación para permiso para corregir la violación. Entonces quiere saber cuál es su solución, si lo va a demoler o si va a tratar de sacar el permiso para corregir la violación.
Pues lo pienso quitar, lo quito y después que lo quite, pues...
¿Puede hablar en el micrófono?
Sí, mi deseo es quitarlo ya, pues no conseguí porque según eso no lo están aprobando. Ese que yo tengo no lo están aprobando. Entonces, pues mi idea es quitarlo y después solucionar o conseguir, es decir, el permiso de construir todo lo que se había quitado, lo que se quitó, y el shell, permiso de todo para poder construir ya legalmente. Pues yo sí le decía a mi esposo que no se podía hacer, pero él pensaba que como él podía hacerlo porque era anexo de la casa. En todo caso, disculpe.
Okay, she says that her solution is to demolish the carport and then afterwards just to resolve the violation, and then afterwards if she decides to do an addition or to do a carport, that she will submit for permits.
All right, she understands it's the shed and the carport, right?
Ya lo quito.
El shed y el carport, o sea, la casita y el carport. Sí. Does she need plans or like some kind of a permit to demolish this stuff?
Typically, the building department, yes, requests a demolition permit for the shed.
Ok, para el shed necesita una aplicación de permiso para que pueda demolerlo, sí, para que pueda quitarlo.
¿O no lo puedo quitar yo mismo?
Can she do it as by owner or?
In the mic.
She can do it whenever she chooses, but she has 60 days.
But she can do it on her own?
Yeah, she can do a homeowner permit.
Ok, sí, usted puede demolerlo, pero sí necesita un permiso, sacar un permiso para poder demolerlo, para que los inspectores vayan a ver
Porque ya
cuando ya
a
lo-
mí me habían ordenado,
Please in the mic.
a mí me habían ya ordenado quitar todo y ya todo se quitó. Lo único que faltó fue eso, porque como estábamos mirando a ver si se hacía que ponerle la parte de abajo, la base, y no se logró, pues yo lo puedo quitar ahora, pero lo demás ya se quitó. Ya yo saqué un permiso. Creo que
Can you
estaba ahí.
translate what she said?
Okay, she says that she did submit for a permit to demolish, and that everything has already been demolished.
So a reinspection needs to be done.
Okay, so she's gonna have to call or contact Officer Ramirez for her to come out and to inspect all of that.
Okay, usted tiene que hacer una cita con la oficial Ramírez para que vuelva a hacer una inspección de la demolición.
Okay. Okay.
But if it's not, the town offering her 60 days to come into compliance or $100 each day will begin to accrue. Does she understand that?
Ok, entonces ella, la magistrada especial dice que usted tiene 60 días, si no lo ha hecho todavía, tiene 60 días para completar el trabajo y si no lo completa en 60 días, bueno, ya va a comenzar o sea, a tener,
Proceder usted.
sí, a tener un cargo de $100 por día.
Okay, yo lo quito hoy mismo, tranquilo.
She says,
She understands she needs a demolition permit to remove.
Yeah.
usted entiende que necesita un permiso para la demolición,
De solo de la casa.
para quitarlo.
Oh. No estaba incluido ahí en el que me habían hecho para quitar la pasada, que se quitó, empezó a quitar todo. Ya no, solamente falta el shell.
She has to confirm. Well, can you translate what she said, please?
She's asking if she really needs a permit just to demolish the shed. And we're going to explain to her that she does.
She said that she has an understanding that she did a permit for a removal and she thought it was included in there. I'm not sure what she's talking about, but that's something she's going to have to discuss with the building department. I don't know if she has a permit, an actual permit, not that I've seen.
Ms. Martha, can you translate that?
Of course. La señora Ramírez dice que ellos tienen que verificar que el permiso que usted sometió era para que incluía también el shed, para demoler el shed. ¿Está bien?
Okay.
And you're going to call her, verify. You're going to
She
verify.
has to call me to let me know when everything is done.
Okay, y que usted tiene que llamarla a ella después cuando ya todo esté completo. El permiso, obvio, y la demolición, para que ella vuelva a hacer la inspección.
Okay. O sea, no quito nada, lo dejo así, ¿ven? O lo puedo quitar.
Tell her she can go to the building department and ask those questions.
Okay, tiene que ir al departamento de building, que es aquí al lado.
Ajá.
Sí, hacer la pregunta a ver si el permiso incluye lo del shed.
Okay. Yo me esperaba, pues. Okay.
So she's going to go to the building department to verify if the permit that she has includes the demolition of the shed as well.
Okay. And if you could just add, just so there's full understanding, that compliance includes applying for the permit, having the permit issued, performing the work within what the permit says, and then having the permit closed and finalized, and then contacting Officer Ramirez to re-inspect so that she understands. Because based on what your translated testimony is, she said she's already complied or moved, but people think getting the permit is compliance, and it's not.
Okay, ella dice que para usted cumplir con esta violación tiene que tener el permiso de demolición, hacer la demolición, llamar a la señora Ramírez para que vuelva a hacer la inspección, cerrar el permiso también. Está bien, eso es lo que incluye cumplir con la violación.
Okay.
Y tiene 60 days, correct?
Right,
Y
the
tienes
town
los 60 días.
Anything else, either side?
No.
Does she have anything else?
¿Tiene alguna pregunta?
No.
Okay.
I think someone's at the.
Está entendiendo.
I'll give oral pronouncement. Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the town's position that violations exist on the subject property. The respondent is hereby ordered to come into compliance within 60 days or face a daily per diem fine of $100 per day until such time as the property is in compliance. The respondent is also assessed $100 administrative cost for today's hearing.
Ella volvió a explicar que tiene 60 días para cumplir. Si no cumple en los 60 días, tiene un cargo de $100 por día.
And the 100 administration costs.
Y también un cargo de administración por $100. Okay. And she has to pay anyway.
Gracias.
In 30 days.
El cargo de $100 de administración lo tiene que pagar en 30 días.
Okay.
O antes.
She can have a seat. She'll get a copy of the
Eso si
order.
no cumplo lo que han pedido.
Bueno, el cargo de $100 de administración lo tienen que pagar. Es el cargo de administración por lo que está pasando hoy. Y tiene 60 días para cumplir con la demolición, o sea, el permiso, la demolición y cerrar el permiso. Después que ella haga la inspección. Pero tiene que cerrar el permiso. Ya puede tomar asiento y le van a dar los documentos.
Jean, can you please help Ms. McKinney do the copy? All right.
Thank you, Jean.
Let me know.
Thank you. I appreciate it.
Officer Ramirez, Attorney Sherman, we can take a 5-minute restroom break.
Okay.
Doesn't appear we have any other live in person.
Let me go ahead and get the recording paused.
Okay. You too.
We're going on a 5-minute break at 11:09 a.m. starting the meeting back at 11:16 a.m. Okay. All right. No one's in the audience, so we'll go in the order of the agenda. All right, starting with section 7.1 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 6620, property owner Murray Family Associates LLP. Site address 3192 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice violation was sent by regular mail February 1st, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail September 19, 2024, posted to the property and town hall October 4, 2024. Violations are for item number 1, demolished Frenchie sign without a permit. Item number 2, demolished Natalie studio sign without a permit. As of August 14, 2024, the property is not in compliance for item number 2. The permit has been pulled, it just needs to be completed. Therefore, I'm giving a recommendation of 30 days to complete it, if not a per diem up to $50 and $100 administration fee.
Case number 6620, property address 3192 West Hallandale Beach Boulevard. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, I find there is substantial and competent evidence to support the town's position as to the existence of a violation. The respondent is hereby ordered to come into compliance within 30 days or face a daily fine of $250 a day. The respondent is also assessed $100 administrative costs. Next case.
Next case on section 7.3 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 8365. Property owner Trinity Broadcasting of Florida. Site address 2250 South Park Road, Pembroke Park, Florida. A notice violation was sent by regular mail April 4, 2023. Notice of formal hearing with a copy of the notice of violation was sent by certified mail September 6, 2024, posted to the property and town hall October 4, 2024. The violations are for item number 1, damaged silt on chain link fence. Construction silt is prohibited, remove. That has been complied. Item number 2, parking lot is in disrepair and is in blight nuisance. Pave and restripe with plans and permit. That has not been complied as of September 3rd, 2024. Item number 3, parking curbs and stumps are damaged, replace or repair curbs and stumps. Item number 2 and 3 needs a permit to be corrected. The property manager has been in contact with me and he says that he's gonna work on it. He has a contractor submitting the paperwork, so we're just waiting for completion. Therefore, it's my recommendation to give 30 days to complete it, if not a per diem up to $50 and $100 admin fee.
Case number 8365, property located 2250 South Park Road, Pembroke Park. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position as to the existence of a violation on the subject property. Respondent is ordered to come into compliance within 30 days or face a per diem daily fine of $250 per day. Respondent is also assessed $100 administrative costs. Next case.
Next case is on section 7.5 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9090, property owner Plaza Hal Corp., site address 4400 West Hallandale Beach Boulevard, unit number 4, Pembroke Park, Florida. Notice violation was sent by regular mail, November 29, 2023. A notice of formal hearing with a copy of the notice violation was sent by certified mail, September 13, 2024. Posted to the property and town hall, October 4, 2024. The violation is for Bernie's conducted a special event on November 19, 2023 without first obtaining a special event permit. As of September 12, 2024, the property is not in compliance. There hasn't been any permit obtained, after the fact permit obtained. Therefore, is my recommendation to get it done in 30 days, if not, a per diem of $250 and $100 admin fee.
Case number 9090, property address 4400 West Hallandale Beach Boulevard. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, I find there is substantial and competent evidence to support the town's position as to the existence of a violation. Respondent is ordered to come into compliance within 30 days or face a daily per diem fine of $250 a day. Respondent is also assessed $100 administrative costs for today's hearing. Next case.
Next case is on section 7.10 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9937, property owner 3680 West LLC, site address 3680 West Hallandale Beach Boulevard, Pembroke Park, Florida. Notice violation was sent by regular mail, July 25th, 2024. A notice of formal hearing with a copy of the notice violation was sent by certified mail, September 17, 2024, posted to the property and town hall, October 4, 2024. Violations are for item number 1, operating without a business tax receipt, outstanding business tax receipt renewal and fees. Item number 2, outstanding certificate of use renewal and fees. Item number 3, pile of tires on premise, dispose of tire, and keep property clean. As of September 13, 2024, items number 1 to 3 are not in compliance. Therefore, it's my recommendation to get this corrected in 30 days, if not a per diem of $250 and $100 admin fee.
Case number 9937, property located at 3680 West Hallandale Beach Boulevard. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 30 days or face a daily per diem fine of $250 for each day out of compliance. Respondent is assessed $100 administrative cost for today's hearing. Next case.
Next case is on section 7.11 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9958, property owner Prologis 2 LP, site address Southwest 38th Avenue, Pembroke Park, Florida. A notice of violation was sent by regular mail, July 26, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, September 17, 2024. Posted to the property and town hall, October 4, 2024. Violations are for item number 1, no parking on adjacent swale area, remove all vehicles and maintain swales according to town ordinance regulation. Item number 2, adjacent swale area is full of trash, debris, overgrown weeds, and dead vegetation. Item number 3, property has become a public nuisance due to unintended overgrowth. Item number 4, prohibited outdoor storage of construction items, remove construction items from property. Upon the failure of the property owner or owners to remove the conditions creating the nuisances as foresaid within the designated time period, the town shall cause such condition to be removed and shall assess the owner or owners of the property for such services in the amount equal to the cost incurred by the town in the removal and disposal of the garbage, trash, rubbish, or other debris. I'm not sure if this particular area will include the construction because they have heavy equipment on there, but they do have to remove it. So far, they have removed partial of the trash and they have trimmed the grass as of September 17, 2024. So for the construction items, I would say to correct it in 30 days, if not a per diem of $250 and $100 admin fee.
Case number 9958, property located at Southwest 38th Avenue. Is anyone here on that case? Seeing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position as to the existence of violation on the subject property. The respondent is ordered to come into compliance within 30 days
Yes.
or face a $250 daily per diem fine in the amount of $250 each day not in compliance. The respondent is also assessed $100 administrative cost. Next case.
Next case is on section 7.13 on the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9981, property owner Plaza Hal Corp. Site address 4400 West Hollandale Beach Boulevard, unit number 4. A notice of violation was sent by regular mail August 5th, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail September 13, 2024. It was posted to the property and town hall October 4th, 2024. The violations are for installation of additional stove, gas line, and hood system without a permit. As of September 12, 2024, there hasn't been any permit obtained, so the property is not in compliance. So it's my recommendation to give them 60 days, if not a per diem of $250 and $100 administration fee.
Case number 9981, property located at 4400 West Hollandale Beach Boulevard, Unit 4. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, I find there is substantial and competent evidence to support the town's position as to the existence of a violation on the subject property. The respondent is ordered to come into compliance within 60 days or face a daily fine of $250 for each day not in compliance. Respondent is also assessed $100 administrative cost. Next case.
Next case on section 8.2 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5518, Lake Villas Associates Ltd, site address 2300 South Park Road, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail September 19, 2024, posted to the property and town hall October 4, 2024. It is the town's motion to confirm the fine of $212,850.
Officer Ramirez, can you give me that confirmation amount, please?
$212,850.
Thank you. Case number 5518, property located at 2300 South Park Road. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fine. To date, the property remains not in compliance. The fines are hereby confirmed. The respondent is ordered to comply and correct the violation. Failure to correct the violation and come into compliance will result in the continual accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 8.3 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5707, property owner XYD Investments LLC, site address 2500 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail September 19, 2024, posted to the property and town hall October 4, 2024. Is the town's motion to confirm the fine of $134,100.
Case number 5707, property located at 2500 Southwest 30th Avenue. Is anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is ordered to comply and correct the violation. Failure to correct the violation and come into compliance shall result in the daily fine continuing to accrue. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 8.4 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez. Should I pause?
Yes, you can continue.
Continue. Case 7112, property owner 1730 PR LLC, site address 1730 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail September 19, 2024, posted to the property in Town Hall October 4, 2024. It is the town's motion to confirm the fine of $30,300.
Case number 7112, property located at 1730 Southwest 30th Avenue. Anyone here on that case? Seeing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains not in compliance. The respondent is hereby ordered to comply and correct the violation. The fines are hereby confirmed. Failure to correct the violation and come into compliance shall result in the continual accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 9.3 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 8797, property owner Lumex Investments LLC, site address 5501 Southwest 33rd Street, Pembroke Park, Florida. A notice of hearing to extend time was requested by the property owner. It was sent by certified mail September 17, 2024, posted to the property in Town Hall October 4, 2024. Is the town's motion to give 90 days? And the per diem, I believe, is $250. Yes, $250 and $100 administration costs.
Case number 8797, property located at 5501 Southwest 33rd Street. Is anyone here on that case? Officer Ramirez, this is an extension, so the respondent is aware of the time?
Yes.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for extension of time. The respondent is hereby ordered to come into compliance within 90 days. Failure to correct the violation and come into compliance will result in the fines, daily or continual accrual at $250 per day until the property is in compliance. The respondent is assessed $100 administrative cost for today's hearing. We can call the next case.
Next case on section 9.4. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9004. Property owner Lumex Investment LLC. Site address 5501 Southwest 33rd Street, Pembroke Park, Florida. A notice of formal hearing to extend time was requested by the owner. It was sent by certified mail September 17, 2024, posted to the property in Town Hall October 4, 2024. It is the town's motion to give 90 days to correct the violations, if not a per diem of, let's see if it's $250 and $100 admin costs.
Case number 9004, property 5501 Southwest 33rd Street. Anyone here on that case? Seeing no one come forward, this is an extension. Officer Ramirez, for this case as well, have you had contact with the respondent with regards to the time?
Yes.
Based on the testimony evidence presented, there is substantial and competent evidence to approve a request for extension of time. The respondent is hereby ordered to come into compliance within 90 days. Failure to correct the violation and come to compliance will result in a daily per diem fine of $250 per day until such time as the property is in compliance. Respondent is assessed $100 for administrative costs. Next case.
Next case is on section 11.1 on the agenda. That's case 7068. Property owner Robert Granger. 1 second. 7060. The property address is 2320 Charles Road. It is the town's motion to vacate the order. This case was brought forth by former officer Eric Richwagon. The reason for the vacation is because there's no evidential support for the violations listed here. So therefore, we are requesting to vacate it.
And just for clarification, this is not, we're vacating, not amending.
Right.
Okay.
Which will mean that the case will be dismissed.
Okay. Check with the attorney. 10. Case number 7068. Property located on Charles Road. Anyone here on that case? Seeing no one come forward. This is the town's motion to vacate case number 7068. The town's request is granted.
Okay.
I do have a question for Attorney Sherman or Officer Ramirez. This is a vacation. Now, is the caption, are we okay with the cat? Because or should it just read vacating, excuse me. It sound like vacation. Should it just read Attorney Sherman?
I understand what you're meaning.
Right. It's either vacated or amended. So if you're vacating the order, it should just be vacated.
Okay. Okay, so,
It's not vacated and amended.
okay, I just,
Well, what we mean is there's been a final order and an amended final order entered into the record. So that was my mistake. I didn't include the amended order. There's a final order that was entered July 2022, and then an amended final order November 16, 2022, and we want to also vacate that amended.
Just what it would say is that the order entered on the first date and amended on the second date is hereby vacated.
Okay. So we can make those, we can add those verbiage.
okay.
If you can just, if you want to wait after the hearing and then we can correct it.
That's fine. I just wanted to make sure that the form matched the substance of what the town was doing.
Okay.
Thank you for that clarification, both.
Let's see. All right. Next case would be on section 11.2, case 5678, Weaver Brenda L. Property address 5405 Southwest 41st Street, Pembroke Park, Florida 33023. This case was brought forth in the past by former officer Teresa Malcolm. And we're requesting to vacate the final order that was entered August 19, 2021, to dismiss the case since there is no evidential support of the violations.
Case number 5678, property located at 5405 Southwest 41st Street. Is anyone here on that case? Seeing no one come forward. Based on the testimony, based on the town's motion to vacate case number 5678, said motion is granted. And Attorney Sherman, just for the record, Officer Ramirez, this one says simply vacation of final order. The substance indicates that case overview final order attached, entered, an error is hereby vacated. So this comports with what the testimony and what the town's motion is. So this one's fine.
Okay.
Oh, okay. Officer Ramirez, with regards to the remaining two cases for vacating, to the extent there's if you could read into the record the final order date and the amended final order date, and the town's position, whether the town is moving to vacate both, so that your testimony comports with the order.
Okay. Next case on section 11.3 of the agenda, case 6892, property owner Holiday Hallandale, MHC LLC, site address 3100 West Hallandale Beach Boulevard, Pembroke Park, Florida. This case was cited by former Officer Eric Richwagen. There's multiple reasons to vacate these. The order entered on May 18, 2022, and the amended final order entered in September 21, 2022. The notice of violation has a lot of clerical errors, and in addition, it's citing multiple RVs, and according to state law, the RVs have to be cited individually. However, they were cited all in one notice of violation to the property owner, and state law says that we have to cite each individual RV owner. So therefore, we're requesting to vacate these orders.
Case number 6892, property located at 3100 West Hallandale Beach Boulevard. Is anyone here on that case? Seeing no one come forward. This is the town's motion to vacate final order entered May 18th, 2022, and amended final order entered 9/21/2022 based on the testimony provided. The motion is hereby granted. Next case.
Next case on section 11.4 of the agenda, case 6893, property owner is Green Acres Pembroke MHC LLC. And let the record reflect there's a typo of the name on the agenda, and it'll be corrected as of today. Okay. No, hold on a second. I am getting them mixed up. That's what it is. Which case we heard just now?
6892.
No.
Previously?
Previously it was 6892?
Yes.
Okay, then I'm I'm getting it mixed up. Hold on a second. Previously, case 6892. I stated in the record it was Holiday Hallandale MHC, which is incorrect. Or did I say Green Acres? I don't remember.
Stated Holiday.
Holiday, right? Okay. That's incorrect. It's actually Green Acres, Pembroke MHC for case 6892. The address was correct, so it's just the name. But I'm sure it was entered correctly on the order, correct?
Yes, the order is correct, and we read the correct case number and the correct property address.
Correct. All right, so now we can move forward to 11.4, case 6893. Sorry, the cases are very similar. All right, for case 6893, Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner, Hallandale MHC LLC. Site address 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida. This case is similar to case 6892, where case 6893, notice of violation has a lot of clerical errors, and the RVs had to be cited to each individual RV owner according to state law, and it was cited to the property owner. Therefore, the town is asking to vacate the final order issued on May 18, 2022, and the amended final order issued on September 21, 2022.
Case number 6893, property address 3140 West Hallandale Beach Boulevard. Anyone here on this case? This is the town's motion to vacate final order entered May 18, 2022, and amended final order entered September 21st, 2022, for the reasons set forth by the testimony of the town. The motion to vacate final and amended orders are hereby granted.
And that concludes all the cases on the agenda.
It does. I do want to recall case number 7068.
706.
That was, I believe, the very first one or second one that we called.
Okay.
One.
Mm-hmm.
Property located Charles Road.
Okay.
On closer examination, the order reflects the body of the order, not the caption. That we are the town is vacating the final order and the amended final order. In a review of said orders, the amended final order was entered this November 16th, 2022, which is attached as an exhibit, and final order issued on July 20th, 2022. So I'm satisfied. We don't need to amend. It's just in the initial testimony, there was no...
Right. Oral pronunciation.
Yes. So this order is fine as presented.
Okay. Thank you. You did good.
If there's nothing else, we motion to adjourn. Okay.
11:48 a.m.
Okay, perfect. And then this one was continued.
Yeah.
Yes. Okay. I don't need to sign anything because when we looked at it again, that was fine. We put on the last one.
What? This one? No.
Yeah, okay, we're good.
But I need to do Joseline,